The police hold significant authority in the United Kingdom, entrusted with maintaining order and upholding the law. This includes the power to detain and search citizens under certain circumstances. However, it is crucial to remember that these powers are not absolute and are subject to legal constraints. Striking a balance between effective law enforcement and protecting individual liberties is paramount. Here, we will delve into the nuances of police powers in the UK, focusing on when they can and cannot detain and search individuals. Understanding your rights in such situations is essential to ensure you are treated fairly and lawfully. It's a common misconception that the police can stop, detain and search anyone at any time. In reality, their powers are far more restricted. The fundamental principle is that the police need a lawful basis to interfere with your freedom of movement. A police officer cannot detain you simply because they feel like it or find you suspicious. They must have reasonable grounds to suspect you are involved in criminal activity. This suspicion must be based on objective factors, such as your behavior, appearance, or information received from reliable sources. They may only detain you if they are going to search you or use Section 50 to ascertain your name. Otherwise, they must either arrest you or let you be on your way. One of the lawful reasons for a police search is the suspicion that you may be carrying illegal items. This includes drugs, offensive weapons, stolen goods, or anything that could be used to commit a crime. These powers are granted by the Police and Criminal Evidence Act 1984, a piece of legislation which forms the legal foundation for stop and search and sets out the powers available to police. The police must have reasonable grounds for this suspicion, and it cannot be based solely on your ethnicity, age, or appearance. For instance, if the police receive a tip-off about drug dealing in a specific area and they observe you acting suspiciously, they might pay you some attention, maybe even engaging in a consensual conversation. However, simply being in the vicinity of suspected criminal activity is not enough to warrant a search on its own. The officer's suspicion must be more than just a hunch. It must be based on an objective and tangible belief. You can only be stopped and searched if a police officer has reasonable grounds to believe that you are in possession of a prohibited item. If an officer does not believe that you are in possession of an illegal item, but does believe that you have committed a criminal offence, then they may arrest you. If neither of these apply, the officer must let you carry on with your business. Section 4. Suspicion is not enough. It's important to remember that suspicion alone is not a blank check for the police to detain you. If the officers do not wish to undertake a search, request your name under Section 50 or acting under a temporary Section 60 authorization, then the police should let you be on your way. If the police have no valid reason to hold you, you have the right to challenge their actions. You can politely but firmly ask the officer, "Am I being detained?" If they say yes, you can then ask, "On what grounds?" The police are obligated to provide you with a clear and specific reason for your detention. These reasons and grounds must be lawful, such as a search under PACE or Section 60, a request under Section 50, or action under terrorism legislation. If they fail to do so, or if their reason is not legally sound, your detention might be unlawful. It is always a wise decision to record the police as soon as you are aware or even suspect that they have an interest in you. By recording the police, you protect your rights, the record of what happened, and it provides documentary evidence for any future claim against the officers. Section 5. Your rights during a stop and search. Being stopped and searched by the police can be an intimidating experience. However, it's important to stay calm and assert your rights. You have the right to remain silent. Most importantly, you do not have to provide your name or any details about yourself except if asked under Section 50 regarding antisocial behavior or you are placed under lawful arrest. If your detention is unlawful and you are arrested on bogus grounds or for something that is not a crime, you do not have to lawfully provide your details. This, though, is a decision for you in that moment with all the circumstances at the time. You can also ask for the officer's name and badge number, as well as the station they're from. They should nevertheless provide this during every stop and search encounter. Remember, you are not obligated to consent to a search. However, if the police have tangible, objective, reasonable grounds to suspect you have an item on you that is illegal, they can proceed with the search even without your consent. It's crucial to document the entire encounter, including the time, location, officers involved, and reasons given for the stop and search. This information can be vital if you need to make a complaint or challenge the legality of the police action later on. Do you believe that many police officers get this right? Have you experienced officers not understanding the detention laws? Make sure you not only know your rights, but exercise them. Use your rights or lose them.
I'm not being funny, but I've been pulled over before and I've been harassed.
Well, we're not harassing you, are we?
Is that your badge number?
Well, I hope it is.
Let's
take a photograph of it, please.
There's been cases of it before, haven't there, where people have been kidnapped?
As my colleague explained, the reason why we stopped you is because you fit the description of somebody acting suspiciously.
I have actually got human rights, and obviously I do understand. I've been committed of a crime, or I'm actually on suspicion of a crime. I don't have to show you any ID.
Right.
I do know me right. You're putting me under alarm and distress now.
I'm a police officer.
Yeah.
Okay.
Which means, but you serve the public. I've had it before where police has thrown me on the floor for asking him, have you got ID? At this moment in time, am I detained?
Yes, you are.
What for? What am I being detained for? You're now restricting my free way of movement, because now you're saying I'm being detained for a crime I've not committed. You're detaining me against my own will from a crime that I've not committed.
Do we speak to the caller?
Yeah.
See exactly what the caller says you have or haven't done.
If I've not committed a crime, I'm a British citizen, I'm allowed to walk up and down the street, I'm allowed to work. You're actually admitting you've illegally detained me for a crime I've not committed. I'll just put a complaint into IPCC.
If you'd like to walk away, you are free to walk away.
I will be sent it to Miller. I'll wait until it's all over the line. I don't trust the fact I can walk away with you, because I'm sick of being frigging harassed at work.
I put a complaint in about to the IPCC, and the claim was upheld on the 1st of the 6/16, and they are taking some action. Some severe action against the police for the way they handle themselves. PC John Gurn and PC Rebecca Jarvis actually refused to identify themselves as West Midlands Police, which is obviously a breach of policy. They did breach my human rights of 1998. They breached Article 3, 5, 8 and 14. It was classed as a breach of Protection from Harassment Act of 1997. For the way they acted. I took them to a criminal court and a civil court. At the criminal court, I was awarded £35,000. One of them was suspended for 2 months with further investigation. One of them was fired, and the other one was given a slap on the wrist and was allowed to still do the job. When I took it to civil court, I further won. It was around about £5,000 due to the way they handled themselves.